Hello and welcome to another episode of Law and Democracy, a podcast of the Election Law Program at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law Program. And with me today are Ned Foley, the Director of our Election Law Program, Tony Goggin and Terry Enns, Senior Fellows of the Election Law Program. And we're especially delighted to welcome as a guest today, Brad Smith, a longtime friend of the Election Law Program here at Ohio State, and a former faculty member at Capital University School of Law, where he was the Josiah H. Blackmore II and Shirley M. Nault Professor of Law. And in his retirement, he continues to be active in a number of ways, including serving at the moment as the president of the Institute for Free Speech. And other listeners will well know that Brad Smith is one of the country's premier experts on campaign finance regulation, and spent 5 years as a member of the Federal Election Commission, including serving as a chair of the Federal Election Commission. So, Brad, welcome. It's great to have you with us today.
Yes, it's a pleasure. I was wondering if you were ever going to invite me on the podcast.
Well, we're into the early episodes of our second season, having just started this a year ago. And yes, we are glad that we've got you here. Thanks for joining us.
All the kinks were worked out and there wouldn't be any problems. I appreciate that.
Very good. Well, Tony, we'll let you kick off our discussion substantively. Where do we want to start today?
Sure, Steve. Brad, why don't we start by discussing your amicus briefs in the pending U.S. Supreme Court case of National Republican Senatorial Committee v. Federal Election Commission. Could you start by just telling us a little about the case itself, the facts, and the issue that's presented to the court?
Sure. So this case involves the question of what are called coordinated party expenditures. Coordinated expenditures have a long history. As people who are experienced in campaign finance will know, the Supreme Court has long held that you can't limit expenditures that are made independently of a campaign. So if a political party or a group, Planned Parenthood, the National Rifle Association, or whomever wants to make expenditures separate from the campaign, those cannot be limited. But at the same time, the court has allowed limits on contributions made directly to a campaign. Well, then the question becomes, what happens, what prevents the candidate from going to a potential donor and saying, now, I know you've given the maximum you're allowed to my campaign, but here's what I'd like you to do. Would you run this TV ad in this market? That would really help my campaign. Well, that would be called a coordinated expenditure, and it's treated as a contribution under the law. Now, the FEC actually has fairly complex regulations for what constitutes coordination, but this has been an issue for many, many years, whether parties should be limited in coordinating with their own candidates. It's kind of a different issue when you're talking about, say, again, groups like Planned Parenthood or the NRA, to use those examples again. But a political party, the argument goes, is of course they're supposed to coordinate with their candidates. That's what the party is for, is to elect candidates. And there's a question as to whether a candidate can really be corrupted by his own political party in giving his campaign. So in a earlier case called this is terrible.
Republican 2.
Colorado Republican 2. I'm blanking on the case. Colorado Republican 1 said that parties could do independent expenditures if they had a separate group of people that never talked to the candidate. But Colorado Republican Party 2, which was decided in 2001, held that there could still be limits on what a party could spend in coordination with its own candidates. Okay, so this is about a 25-year-old decision. The NRSC, that's the National Republican Senatorial Committee, wants to spend unlimited amounts to support its candidates. And basically, they sued in court, challenging the earlier decision, asking for that decision essentially to be overruled. Quite naturally, they lost in the lower courts, which are bound by the Supreme Court precedent. The challenge was in the Sixth Circuit here in Ohio, and there the Sixth Circuit upheld the provisions of the law, ruled against the NRSC, but it did note in several of the opinions, both in the majority opinion, in some of the concurrences, and in one dissent, that maybe Colorado Republican 2 was out of date, that it's an old case. There's been a lot of water under the bridge. The way the court has decided other cases in the years since have been more protective of free speech, more skeptical of the corruption rationale. And so this kind of teed it up for the Supreme Court to take on certiorari, and it has done so. So the basic question will be, can a political party spend money, which has to be raised under limited contributions? You can't, Elon Musk can't give $200 million to the Republican Party or something. Can the political party then spend this money with its own candidates without limits, in coordination with those? And coordination means, talking about where the ad should run, what the messaging should be, what the polling data is saying, all that kind of thing that goes into a campaign.
And just quick clarifying question. What about direct contributions from the party to the candidate as opposed to just a coordinated expenditure? What's the law on that, and will this case implicate that in any way?
Yeah, so it's an interesting point, Ned, because as you imply, direct contributions to a candidate from a political party are limited. In fact, many people have also complained about that the parties are treated no differently than any other political action committee, or what we might view what some would call a, quote, special interest. And, you can make a pretty good argument that maybe parties should be treated differently from those other operations. This case doesn't directly raise that issue, but it's easy to see if the court rules that a party can do unlimited coordinated expenditures, that the very next step might be to come back and say, well, then why can't we just give money to the candidate directly to spend? And again, the argument the parties would make, I assume, would go something like this. Contributions to political parties are limited to amounts that Congress has deemed not to be corrupting. And so if we just want to give it to the candidate, as long as it's not earmarked, if somebody doesn't say, I'm giving you the money so that you'll give it to the candidate, which seems to get around the limit on what you can give to the candidate. But if you just give it to the party and leave it to the party to spend how it thinks is appropriate, I think the parties are very likely to make that the next case if they win in NRSC.
Thanks. And I take it the argument would be that that if we're dividing the world between sort of political insiders and political outsiders, contribution limits from outsiders to insiders can be regulated, but then once the money crosses that fence, it should be fungible among those who are on the inside, such that
you're sort of moving money around. And the constitutional argument, again, would be that it's not really corrupting, that a party can't corrupt its own candidates. But there is a simple, practical political argument. Our system of campaigning and campaign fundraising since the passage of the Federal Election Campaign Act in the early 70s has been very candidate centered. It's really focused around the candidates raising money, and the position of the parties has been somewhat diminished. Now, there are many people, and by the way, there are many who disagree, but there are many people who think that the party should have sort of a special favored position, that parties play a role. Parties are interested in winning races, so parties are more interested in picking candidates with broad appeal rather than a special interest, which wants a candidate who's focused on their issue and might even prefer to lose with a candidate who's focused on their issue than win with a candidate who doesn't really care about their issues, kind of, vaguely with them, but not really going to do anything about it. And so there is this kind of, tug there on the policy issue, whether parties are a moderating force, which is what the parties would argue, or whether what the court held in the Colorado 2 case, in an opinion that was written by Justice Souter, the parties are just sort of essentially bagmen for corrupt actors. The corrupt actors give it to the party with a wink and a nod, and the party smuggles it on to the candidate to get around the contribution limits to the candidate. And so that's, the policy argument that's going on behind the legal argument at the Supreme Court.
And do you have a view, there's this political science literature that I'm familiar with that makes the argument that parties are the more moderating force, and that our politics would be less polarized if parties had greater clout in our overall political system relative to super PACs and the so-called independent expenditure committees and so forth. I don't know whether your analysis of this issue tracks that or differs from that?
Well, I'll answer that question. I appreciate that I'm a guest, but I'm very curious as to your thoughts on that, Ned, because you've written a lot about polarization recently. But that has long been my position. I think the parties have an incentive to try to appeal and nominate candidates who can win a general election, that people who are heavily involved in the parties will tend to be more attuned to the overall picture, so to speak, as opposed to focus on something that just gets them riled up and excited. I think, in other words, the more casual voter, and let's face it, most of us are pretty casual voters. Unless you're just like politics, there's not a lot of incentive to spend a lot of time learning a ton about the candidates. And more casual voters are perhaps a little more susceptible to sort of, demagogic appeals that overly simplify issues, that say, the only problem is our party doesn't fight hard enough. We need to fight, instead of what I think is the core of politics, which is compromise. So, I've tended to believe that view. Now, I will say, in recent years, I've had more doubts about that, simply because it seems that the party mechanisms themselves, local party committees, state party committees, are more and more being taken over in both the major parties by sort of cadres of, what we might call ideological zealots, for lack of another term. And so I'm not quite sure that parties are quite the moderating influence that they might have been in the past. But overall, if you were to ask me, I still think that's probably right. And I think it's probably something that we should be encouraging. And to the extent it's not right, it's probably still good to have parties, that have some ability to discipline members, have sort of a unified message that makes it easier for the voters to choose and to decide, which of the two parties do we want to put in power.
Brad, in your brief, the Institute for Free Speech, you make a really interesting argument about evidence, evidence of corruption or the lack thereof. Could you discuss what the FEC's evidence is, or has been historically, that they've offered in defense of the ban on coordinated expenditures, the restrictions on coordinated expenditures, and your argument that evidence doesn't withstand scrutiny? Could you provide your take, basically, on the role of evidence in this case?
Sure. This goes beyond this case, actually. It's long been a battle in campaign finance, which is, what kind of evidence of corruption is needed. Now, again, for those who aren't specialists in this area, the Supreme Court has long held that that there's a First Amendment interest in spending money to voice your political views. Spend your own money to voice your own political views certainly involves the First Amendment, right? The question is whether there are countervailing interests that would justify sort of limits on that spending. And the Supreme Court has long held that the only sufficiently weighty government interest is preventing corruption. In other words, a lot of people like to think, we should all be equal. We should have equal voices. Those people just shouldn't be allowed to spend so much. They drown out others. The Supreme Court's rejected that. Their view is, if the First Amendment stands for anything, it stands for the idea that the government should not be in the position of deciding this person has spoken too much, this person has not spoken enough, the voters haven't heard enough from this guy. That's exactly what we don't want the government trying to pick and choose. So you let it go out and let there be something of a free-for-all. Now, the question then on the corruption side has always been, what evidence do you need to show corruption? Historically, the evidence in favor of corruption is sort of a common sense notion that most of us have, right? Somebody gives you a whole bunch of money, you feel sort of indebted to that person in some particular way, right? This is not a shocking revelation, I think, to most people. But the countervailing evidence is that this doesn't really show up in systematic studies of how people vote and how legislatures act. Generally, it appears that people give money to candidates they already agree with. They don't give money to people they disagree with and hope that will cause those people to change their voting record in some substantive way. And because the court's very concerned about issues of vagueness, it's very concerned about the idea that there's nothing wrong with an office holder being responsive to the people who helped him get elected, right? If somebody helps you get elected, of course you're going to want to talk to that person before you talk to the people who opposed your election, right? And so the Supreme Court doesn't want to interfere with that kind of what we might otherwise call responsiveness or priority setting by the legislatures. And so it has defined corruption quite narrowly in a way that's more easily proved. Not necessarily bribery. If it were bribery, we just have bribery laws and we wouldn't need campaign finance laws at all. But something much closer to bribery, what it consistently calls quid pro quo corruption, sort of a tit for tat exchange. You give me this, I'll give you that. So on the one hand, we have this sort of common sense view of how money operates. But when it comes down to it, you can't find many examples of that kind of quid pro quo exchange that don't cross the line into bribery, where the candidate is not taking cash for his personal use and spending it on luxury goods or vacations or whatever it is. You just really don't find that very often. And studies, again, consistently fail to really find that connection. Now, part of the problem there would be that money probably works much more subtly than that quid pro quo, right? You get money, so you kind of, well, I'm on the fence on this, but gee, the people I really like, they feel this way. It influences us in that more subtle kind of fashion. But again, I think the rejoinder to that you'd get from the court is, how do you stop that? I mean, candidates, office holders are always going to be responsive to some people more than to others. They're going to be responsive to friends and family. They're going to be responsive to others. There's an old story that advocates of campaign finance regulation like to tell. They say, you come back, you're a congressman, you come back from lunch, you got 20 phone messages on your desk. Who do you call back first? You call back the big donor, right? And I'm like, well, not necessarily. Actually, the first guy you probably call back is the reporter from the New York Times. And then you call back, the other reporter that you like. And then maybe you call back, again, somebody who is the local union president or something like that. Maybe you'll get to the donor. So I don't think it's quite as easy as people think. And this is basically the argument that one of the arguments we make in our brief is simply that there's not a lot of evidence of this kind of corruption taking place. And that, this vision, like I say, of Colorado Republican 2 versus Federal Election Commission, that the parties are sort of bagmen for a corrupt enterprise. There's just not really, I think, much evidence of that. I think it's more clear that parties just want a person who can win, who is at least loosely allied with the party. They just want, if they're the Republicans, they want an R after the name. If they're the Democrats, they want a D after the name. That's all that they really care about. And the candidates themselves, tend to have strong views. That's why they got into politics to begin with, and they're not so easily swayed. And so if we really start to look more closely, we find that the evidence isn't there. One of the problems you have, I had one more final thought on this, is that to much of the public, the idea of corruption is a much broader view, and it's a view that often is really unrelated to campaign giving and spending, but when they hear campaign giving, that seems corrupt, and this other stuff seems corrupt. What is this other stuff? They don't like it when they feel like a candidate has reneged on his position. He says, I'm for government. We're going to stand up to Trump, and we're going to shut down the government if we have to. And then later he decides, well, maybe this wasn't a good idea, and he changes his mind, to take a current controversy, something like that. And people feel like, he's corrupt, he switched, we couldn't count on him, or he promised something in the campaign, and then maybe he couldn't do it, because there weren't enough votes. He had to compromise to get half a loaf or something. But people sometimes feel that is corruption, or they feel that it's corruption when people just make money while they're in office, and some people do. Some people may do it corruptly, but some people probably do it honestly. There's a sort of a vague feeling that politics is corrupt, and you find, for example, in the survey data that if you ask voters, a very sizable chunk of the electorate thinks that congressmen routinely, not rarely, but routinely sell their votes for amounts as little as like $100 campaign contribution or $200 campaign contribution. And I think almost anybody who actually works with people in the legislature just knows that is just not true. And I sometimes, when I face that from audiences, I often ask them, will you change your view for $200. Well, no, they would never do that. But they seem to think that congressmen are just a lower quality of people. They're just that Congress is just kind of a prison for people who haven't been convicted yet, and that all these folks should, are just corrupt. And they use it in that very broad sense of the term. The court doesn't do that. It's looking for really specific examples where I say the guy tells me, he says, well, I'm really not in favor of that tariff bill, and I says, well, we've got a $5,000 or $10,000 campaign contribution, and it hinges on your support for the tariff bill. And I'll be rethinking my position, and then eventually comes around. But that just doesn't happen very much.
I've got a two-part question that is in part a follow-up on Tony's evidentiary question, but it starts in a different place. You said in your introduction today, your overview, a little bit about how, in some sense, at least NRSC's argument is that Colorado 2 is now out of date, kind of an anachronism in the law, and therefore they'd like the Supreme Court to overturn it. But you've gone farther, or at least your organization and the Manhattan Institute in the jointly authored amicus brief in arguing that Buckley itself is not analytically sound today. And that is a more sweeping sort of argument. And I'm interested in just having you articulate that a little bit. But then the second part of that is the evidentiary thought I was having, that when the Federal Election Campaign Act amendments of 74 were passed through Congress, at least one way of thinking about that is that was Congress's response to a series of events, mainly in the 72 presidential election, that arguably some might point to as evidence of certain kinds of corruption in the system. And I suppose then a follow-up in all of that is, might somebody say that the absence of a lot of evidence since then is itself a reflection that the law is working?
Sure. So those are all good questions. Let's kind of start with the last thing first. I'm skeptical of that argument, although I think it's, again, an intuitive one. The reason I'm skeptical is because we do have state laboratories, and there are states such as Utah and Oregon and Virginia which have long histories of not placing any restraints on spending or contributions to candidates. And I've never seen anything suggesting that those states are certainly more corrupt, or that they have more corruption scandals or anything, or even that they're not as well governed. In fact, routinely when sort of good government groups, or groups like the Pew Charitable Trust used to do this regularly, they've kind of stopped in recent years, but they used to every couple of years rate the states for best governed states. And oddly enough, the states that had no limits on contributions and spending were almost always right at the top of that list. Now, maybe we got cause and effect mix-up. Maybe because they're well-governed states, they haven't needed limits, and when they have some scandals, they'll impose limits. There's these kinds of issues, obviously, that come into play. But I've just not seen much to argue that in states that don't have limits, this is a real problem. And I've not seen an argument as to why it shouldn't be a problem if, in fact, campaign contributions work that way. Note, there's lots of ways people have political influence, and I often note that Fortune 500 companies, which people seem to worry most about, I think, is corporate power. Fortune 500 companies spend far more money on lobbying than they spend on campaign spending and campaign contributions. They'd much rather spend money lobbying than trying to appeal to the public. They want to go in and talk directly in the office. So I'm a bit skeptical of that argument. Now, in our brief, we do argue, and this is something that's nice about writing an amicus brief, is you can kind of suggest that maybe the court's been looking at things all wrong, where we don't have to win this particular case, in which case you might want to stay focused on, the most immediately relevant precedent that you think the court will feel compelled to follow that supports your case. And we've argued that the Supreme Court erred in Buckley v. Valeo by holding that Congress could regulate this stuff at all. Again, for people who aren't specialists in the field, Although the federal campaign laws go way back to the early 20th century, the first law that really had any bite, any teeth, was the Federal Election Campaign Act, and more specifically, amendments to that act, essentially a complete rewriting of the act in 1974, passed in 1975, immediately challenged in court, and the Buckley decision was issued in 1976. And Buckley struck down much of that act, a great deal of that act, but it left intact some of the core provisions, including, as I say, limits on contributions to candidates and parties and to PACs, and a regulatory apparatus and mandatory disclosure and so on. One of the things we argue in the NRSC brief, we being the Institute for Free Speech, is that Congress really doesn't have this power at all. In Buckley, the court makes a passing reference to the Elections Clause of Article 1, which gives Congress the power to alter the time, place, and manner of choosing senators and of congressmen, and then later senators through amendment. And then Article 2, which gives it the ability to alter the time and place of choosing the president or presidential electors. It doesn't say anything about the manner of presidential electors. Our argument is that time, place, and manner does not include campaign. That what Congress is regulating here is not an election, it's regulating a campaign. And while these two things go together, they're not the same. Pregnancy is not the same as birth. They're different. Although again, one will tend to follow the other. But that's why we have dividing lines. Oftentimes, all through life, we have things that divide one period from another. College basketball season's going to start in the next few weeks, and teams will play exhibition games. And if you look at them, those look almost exactly like regular season games, but they're not. They're different. And that's what we argue is a campaign is not something Congress can regulate. What is the campaign? What is a campaign? Especially in this country where we don't have snap elections called by Parliament, the campaigns run perpetually. I was once asked by somebody, when did Hillary Clinton start running for president? And this was, I don't know if it was the 2008 campaign or the 2016 campaign. But I remember my answer, which was, I think sometime around 1974. I mean, we campaign all the time and in a great many ways for public office. And almost all discussion of public affairs ultimately is intended to influence who is in office and what they do. As Justice Holmes once said, every idea is an incitement. You don't engage in political discussion if you don't hope that it's going to persuade somebody maybe on how to vote or something like that. So I don't think that the court was correct in just saying, well, Congress clearly has the power to regulate the time, place, and manner of an election. By the way, the time of an election, pretty clear what time is. The place of an election, pretty clear what place is. The manner, that's what they hinge it on. But note, that doesn't apply to presidential elections at all, and yet we limit presidential campaigning. And even if we take manner of an election, the manner of an election is who's eligible to vote, how the voter rolls are maintained, what kind of voting machines you use, what polling hours are open, those kinds of questions, how the votes are counted, what are the recount procedures. That's the manner of holding the election. The campaign, how many people are out there now who we all think are running for president, but they don't have declared candidacies? Gavin Newsom doesn't have a presidential campaign committee yet, but, every day you can pick up any newspaper in the United States and find some reference to Gavin Newsom is, probably going to run for president in 2028. We argue that there is a difference between those two, and Congress simply lacks the power. And when you combine that with the First Amendment, which makes very clear that you cannot restrict political speech, and the court has repeatedly said, I think correctly, that political speech is at the core of the First Amendment. I mean, it protects other kinds of speech too, but the reason we have it really is so that people can debate the issues that we have in a democracy. I think it makes clear that Congress really, does not have the authority to be regulating in this area at all, and that's a mistake of the court. For some people, that would be shocking because it says essentially we'd have deregulated campaigns, no restrictions on the money flow and so on. Now, you can still have bribery laws. I think bribery is a long-established crime, but the idea that you could regulate campaign giving and spending for the purpose of regulating campaign giving and spending is, I think, contrary to both the powers and structure of the Constitution, and then contrary to the First Amendment as well.
Brad, can
Can I ask
Go ahead, yeah.
sort of a follow-up? So there, as you mentioned, there are states that don't have limits. There are states that do have limits. But federally, we've been living for about 50 years with limits. What do you think would change on the ground, for better or for worse, if you're right and the court says, okay, yeah, Congress, you didn't have any business deciding Buckley the way you did?
That's a great question, and if I can answer with a little anecdote, sort of first, it's great in part because, in a sense, we almost don't know these political operatives. They are clever people, and I'll just tell you, the Institute for Free Speech and I and along with the Institute for Justice were co-lawyered a case called SpeechNow.org versus Federal Election Commission. And this is actually the case that actually created super PACs that said if a group is only doing independent expenditures, it's not giving money directly to candidates, then it doesn't matter how much people give to that group. Before that, the FEC had rules under the law that limited how much you could give to some group, even though that group wasn't giving any money to candidates. So Speech Now says, no, if David Koch can spend as much as he wants, and Ed Koch can spend as much as he wants, if they get together, they can still spend as much as they want. And if they give it to some other group to spend it for them, they can do that, right? All of the time that we litigated this, and this was fiercely litigated by the pro-regulatory groups, they were, obviously adamantly opposed to it. It was briefed in the lower courts and up to the Court of Appeals, and then en banc in the Court of Appeals, and nobody ever thought of the idea of single candidate super PACs. That is a super PAC formed to support just one candidate. Almost immediately, the political consultants thought of that after the Speech Now decision was issued, and you saw the rise of a super PAC that existed solely to support the candidacy of one candidate with independent expenditures. And that would be a whole other discussion whether that's good or bad, but that was just not something that anybody anticipated while it was being litigated. So finally, to answer your question more directly, I mean, obviously it would strike down if the theory we've proposed, and I kind of call it separation of campaign and state, if we were to enact that theory, contribution limits would go by the wayside, efforts to any remaining thought of spending would go by the wayside, of limits on spending, although those have always been struck down on First Amendment grounds. I think that efforts to have the government pay for campaigns, which I think is to me fundamentally contrary to the democratic ideal, and that may be another thing we want to discuss, but that would go by the wayside. So yeah, you'd have a deregulated system. And what would that look like? Part of my answer is always, that's how we ran our campaigns still for the majority of the country's history. As you point out, we had 50 years of the Federal Election Campaign Act, but for most of history, people have been able to spend what they want. There were laws in the early, throughout most of the 20th century, but they were sort of Swiss cheese laws. They were as a practical matter, had very little effect on raising and spending of money. And I think few people would argue that we have better politics or that we're better governed in these 50 years than we were in the days prior. There are some things that are probably better. And I actually do think, although, again, the general public won't think so. To them, all these guys are corrupt. But I think actually congressional ethical standards are higher than they probably were 50 or 60 years ago, oddly enough. But I don't think there's much evidence that as a country we're doing better in our politics and in our governance. And I think we find that maybe it would restore a bit of honesty in a sense, because the public senses this constant search for what we'll call loopholes, for lack of a better term, ways to work around the law, to campaign without really campaigning, to do these kinds of things. And I think that feeds the cynicism to some degree. So that would at least be my hope, is that maybe in the end people would just say, yeah, politics is corrupt business, but they just go at it, and we, the voters, decide, we get to cast our votes in the end, and we hear everybody, and you don't win or lose the campaign because you have better lawyers or better accountants or better consultants who are better able to figure out this extensive campaign finance regulatory regime.
Can I ask one technical question about the argument that the Congress doesn't have this power? It's been a long time since I read a case, I think, called Burroughs from the 1920s, if I remember, that gave Congress some power, and maybe that was a bribery, case, but it was about giving Congress some power over spending. What was the theory of that, based on the elections clause or some other clause? How does that relate to this argument?
Okay, so Ned, you got me here. My recollection is that they do, again, give a quick passing reference to the elections clause, but I have to say, now that I've just said that on what would be a public podcast, I'd rather not be quoted on that. I haven't read that opinion in ages, and I don't, sometimes you forget whether the court actually specifically relied on that clause or whether they were talking just about Congress's broader authority. You note that there would be some regulation that would still be allowed. For example, anti-fraud statutes would still apply, and certain things like that that are general laws that apply. But you couldn't have this kind of regulation that targets political campaigns if our theory were adopted. Now, I think the odds of the court adopting our theory, at least in this case, are very, very slim. But we think it's right, and we felt it was time to try to, I guess you could say, inject that in the debate, present that argument to the justices, let them begin to think about that. Sometimes people, you have to be presented with an idea. You're not immediately bowled over by it, but over time you begin to think, the more I think about it, that maybe that's correct. And we just felt it was time to start to get that idea out there. If the court were to adopt it in NRSC, I would be stunned. I would immediately want to know whether somebody was forging Supreme Court opinions or whatever. But it would be great, and I'd be delighted if one of the justices, maybe Justice Thomas or someone, were to say in a concurring opinion, maybe we don't even have maybe Congress doesn't even have the power to regulate this.
I've always thought that the residual commerce clause power would suffice, because I think there is something to your argument about the elections clause being about election administration. But and I know the scope of the commerce clause is narrower than it was back in the 70s when the federal campaign finance law was adopted. But I still wonder whether or not the federal government or Congress could say, we're regulating money in the electoral system not because it's a direct regulation of the electoral process, but we're regulating it because it's an element of the overall national economy.
Yeah, I think that's an excellent point. It's interesting if you go back and read some of the really early decisions of and not just the really early legislation. For example, the Federal Corrupt Practices Act initially applied to campaign committees that are operating in 2 or more states. And the very idea was you have to have interstate commerce. And of course, in those days, the interstate commerce was viewed more narrowly than it was before the sort of New Deal revolution and eventually Wickard v. Filburn. And so there was this sense that you had to be, a state race wouldn't qualify. Now, again, under Commerce Clause jurisprudence, which would be a whole nother issue, I think they've defined the Commerce Clause too broadly, but that would be a problem. Here's what I think, though, on that, which is that it would reinforce, in a sense, the First Amendment imperative here, because what happens now is there's this kind of argument, or at least this implicit assumption. We have the First Amendment's here, and the First Amendment's important, and maybe this law can't pass First Amendment scrutiny. But on the other hand, there is this explicit authority to regulate the manner of elections. It gives some more weight against that First Amendment. And I think if we begin to realize that, no, you're only talking the Commerce Clause, I think that argument becomes weaker. And in fact, I think it would be tough. You have the question of, will Congress look behind the words, so to speak, if Congress or state legislature, I guess it would be Congress, says, we're going to pass this because we're passing this under commerce. And you're like, well, what is the economic regulation here, really? What is the public health, safety kind of thing? How does this fit under the traditional police power? Because it sure looks to us like you just want to cut out certain political speech. You think certain political actors, maybe corporations, have too much power, maybe unions have too much power. Those are usually the bogeymen, or maybe just a few wealthy individuals like Elon Musk and Tom Steyer and, the guys like that have too much power. Kind of categorical rules. I think it's a weaker looking argument if you're trying to justify it under the Commerce Clause, in part because frankly, it probably would be a pretextual argument. They're not really concerned about the economics of it. They're just deciding, well, what the heck? People are spending money, so maybe we can regulate it.
You mentioned snap elections in parliamentary democracies, and that caused me to think about a number of differences in how elections are conducted in many other democracies. And just articulating it that way, I said how elections are conducted in other countries. And I think of how elections are conducted as almost equivalent to the manner in which elections are conducted. And in many countries, that how they're conducted includes time limits on certain aspects of the campaign. That's what a snap election does in a certain indirect sense, but other countries actually say you can't start using your political speech rights until a certain moment. And that, at least in certain fora, and that has always seemed to me to be consistent with one understanding of what the manner of conducting elections might be. I understand the narrower argument that your brief is making, but is there anything to be learned or rejected from what's happening in other democracies? This is a comparative point, and I'm not a very good comparativist, so I'm sorry.
No, it's a great point. So I think a couple things that I would respond. First is, of course, our First Amendment is generally stronger than most other countries have, and I think that's a good thing. And some people may not, and I almost feel like, okay, let's go have another debate about that, but that's going to be a couple hours, separate from this podcast today. I think it's good that our First Amendment is stronger than what other countries have. The other thing is that in parliamentary democracies, the election date is typically not fixed. I mean, there's usually an outer limit for it, but actually that outer limit seems to be reached relatively infrequently. Usually one party will call an election before then. And, if we were in a position where you didn't know that the presidential election was going to be in November of 2028, and rather, or the congressional elections in November of 2026, and rather, Republicans could say, hey, we're looking pretty good in the polls. Let's have an election in January, right? Okay, we got 3 months, everybody starts campaigning. And so in a sense, you can cabin that off a little more and maybe say it's part of the manner of holding an election. I would still kind of disagree with that, the idea that it's the manner of holding an election. It's more just a different legal First Amendment, or I guess I should say free speech tradition in those countries. But it is a little bit more of a clear kind of cabined off period. Now, having said that, even in those countries, it's not so neatly cabined off as people think. And indeed, again, in recent years, one thing you see is as the state grows, and the state has grown all over the world, it's grown through all the modern democracies, and there are many advantages to having a bigger state, health and safety regulations, a social safety net, and so on. These are things that are debated ad nauseum, but most people agree that at least some of this is beneficial, and in many cases, a lot of it is very beneficial. But that will attract more money and more campaigning into campaigns for public office. And so even in countries that, have these sort of, we'll call the election 3 months from now, okay, the campaign period is 3 months or something, we'll see the parties increasingly jockeying for position in the interim. They know what the issues are. And, I think you see what you might call the surreptitious campaign, that sort of campaign that won't describe itself as a campaign, precisely because if it describes itself as a campaign, it gets subject to all the regulations and you can't do it. But in the meantime, they are trying to lay the groundwork, and they're trying to guess at when that election is going to be called by the party in power. So I think there's something to your point. I think it can be overstated, but I think to the extent that you make a very valid point, my response would just generally be to say I don't think that's consistent with what our First Amendment provides and requires, and at least from my perspective, our First Amendment is better than their free speech rules. I don't suggest, by the way, that these countries are like not free liberal democracies and so on. They are. I mean, we do things differently. They do things differently. I don't think that you can, focus so narrowly and say this is the essential element of a democracy and it has to be exactly like ours. We might say free speech is an essential element. I don't think everybody has to have the exact same definition of what that covers and to say that you're a good democracy. But I do think, I prefer our system, our broader extension of First Amendment rights, and I think it's beneficial for us.
But that seemed to be saying that it's the First Amendment that really matters, not defining what the manner of elections is.
Well, but defining the manner of elections, because we have it specifically written in the Constitution, right? I mean, one could say, well, an election is anything connected with electing the candidate. I tend to think that's a pretty sloppy use of the language. I don't think that's that good. And I don't know that other countries actually use elections. They may just say, we just think you can regulate political speech because they don't have as much restrictions on political speech as we do. So I don't want to get caught in a semantic game of comparing countries. I'm just going to say that in our country, I don't think the manner of an election includes, all the things people say and do and how they position themselves and efforts to persuade other people as to what they want to do. I don't think that's what the Constitution was talking about when it says the time, place, and manner of an election. What they meant there was they wanted to make sure that the states would not kind of rig their actual electoral process. That is the election of people, the votes who got to Washington in order to undermine the federal government. And I don't think they would have viewed it as something that was a green light for states to start regulating, how people talked about politics, who they talked with about politics, and some of those other things that we regulate in the name of campaign finance reform or the manner of an election. And if I'll say again, if you just want to get to some specific textual support for it, I will go back to that point that there's no manner clause in the presidential elections. Nothing there about manner at all there. So where, how do we figure that you can regulate presidential elections? And if you can't, why is it that you can't? What's the difference here?
Brad, NRSC v. FEC is obviously a very important case for all the reasons you've laid out. But I wonder if a case can be made that deregulation of our campaign finance system, or at least our campaign finance practices, has already occurred because of technological change. If you look at the last three presidential elections, Hillary Clinton, Joe Biden, and Kamala Harris really greatly outraised and outspent Donald Trump. And yet, the evidence is very compelling that Donald Trump actually reached far more voters, was able to communicate with far more voters using free media through, not just through the powers of the presidency when he's incumbent, but through Twitter, and then later through Joe Rogan and YouTube and all kinds of other platforms that has fundamentally changed our campaigns. And so in a way, one might view this as a case where the Supreme Court is being asked to simply catch up to a changing reality that has unfolded regardless of what the court ultimately says, and that this is just a situation where the court is being asked to bring the law up to date with practices on the ground, not just the evidentiary issue of the last 50 years of corruption, but the new way that candidates reach the electorate. What do you think of that argument?
I think it is a very valid argument in many ways. I'm reminded Jess Unruh, who was an old California political operative in the 1960s and 70s, made a famous quote. He said, well, there's two things important. I might not have this exactly right, but he basically said, there are two things that are important in politics: money, and I can't remember what the other is, right? That it was, he said, you've got to raise the money. And money obviously is still very important. It doesn't dictate who wins elections, though. And oftentimes your ability to raise more than your opponent is because you're a good candidate who's going to win the election anyway. The same thing that makes you an attractive candidate makes you a good fundraiser for your campaign. But I do think one could at least make some argument that, through the internet, there's a lot more opportunities for sort of what we'll call ordinary citizens to have a major impact on the campaign, to create a TikTok video or a YouTube video or something that kind of goes viral, as they say, and creates some vibe that actually makes some difference in the campaign. It's a lot easier for people to get their work published where a lot of people might see it. Anybody can set up a Substack account, and it's surprising some of these take off. People start saying, hey, you should read this guy's Substack out. Who is this guy? I have no idea, but you should read his account. It's really good, and some of these things begin to come into play. Whereas, 50, 60, 70 years ago, you had a handful of sort of national newspapers, and they had their columnists who were, carefully selected, and maybe the local newspaper had one columnist, and, there's a much more constrained system. I do think some of this may have made money a bit less important, although let's be, frank here, right? Spending keeps going up. You've seen the spending on campaigns going up. So I guess the candidates still like to raise as much money as they can. You never want to lose a campaign because you didn't have enough money. Let's put it that way. So I think that though that you're right, that there's some indication that things have changed. And more specifically to your question, is it already deregulated? I think to a large extent the answer is yes, or a better way to put it is our regulations are just out of date. And this is true across much of the regulatory front, but I think it's very true here that the regulations don't really keep up. The FEC regulations still talk about unions and corporations in a way as if it were 1977, or 1978, and how they operate and exercise political influence. They still give examples in some of the parts of the regulations where they give examples. They give examples of things like skywriting. Now, when was the last time you saw a candidate campaigning with skywriting, in a play? So it's very hard to keep the regulations up to date in a fast-moving technological world. And when you couple that with the fact that the deregulatory side, I guess my side has been actually pretty successful, and the courts have knocked down a number of the rules as well. You end up with a system in which there is more play for people to do things, and so it's easier to work around or find an alternative to the regulations that do exist. And then people begin to say, well, why do we bother with those regulations? And so there is a bit of a snowballing effect that would lead one to say the system is already deregulated. Having said that, I always point out one thing. People say, it's the Wild West out there. And I'm like, no, campaign finance is a heavily regulated industry. There are thousands of pages of statutes and regulations. Grassroots campaigns find it extremely difficult to comply with the law, which again can be very complex and voluminous. And that's one reason why I think in the end that it's kind of a deregulated if you can hire really good lawyers and accountants who specialize in the field and are really good at it. But if you're a small, long shot campaign that might have a chance, but it's going to be a tough one. If you're a grassroots group trying to form on some local ballot initiative, which, by the way, is one of the things I think is really damaging about campaign finance regulation. The limits are way too low. We start requiring disclosure in many states of at $10. You have to start forming, political committees and all the bureaucracy that goes with them for people that are running for an office where they're going to spend $2,000 to be, village trustee or something. Anyway, at those levels, the law is really hard. So we have a system that is not deregulated, but if you have the good, talented people, you can really work the regs. And if you don't have those people, you're suffering under, again, hundreds and hundreds of pages of regulations and statutes.
Well, everyone, we are out of time for today, but this has been a very rich discussion, and we sure appreciate you being with us today, Brad. And it's great to be with all of you. And so we'll leave it there until next time.
Well, thank you very much for having me. It's good to see my friends. Thank you.